We can, but it won't record.
Oh, you're trying to record, okay.
Hi, it's a pleasure being here today. So, it'd be good if I turned it on. Okay. It's a pleasure being here today. I appreciate you doing this and having this interview so that we can get more information out about our judicial candidates. My name is Robert Kurth. I'm running for Justice of the Peace Department 5. I grew up here in Las Vegas, been here for 42 years. I did my education here, left, went to BYU on an academic scholarship, met my wife, came back, got married, had a couple kids before I got out of UNLV, graduated from there, went on to law school in the University of Denver College of Law. I had my third child about 2 months after I got out of there. And I have 4 kids, 3 in college, 1 married, and 1 13-year-old at a fast pitch softball tournament in Arizona with my wife right now that I had to send her off to so I could make sure I could be here and attend this event. So I've been practicing law here. I'm in my 20th year practicing law. I've had a general practice of law during that time. And I gave you some information. I appreciate if you look at that, and I appreciate your support.
Hi, my name is Cynthia Dustin-Cruz. Can you hear me now?
Yep.
My name is Cynthia Dustin-Cruz. I have been a lifelong resident of Las Vegas. I've done all of my education here, growing up through the public education system, continuing on to get my undergraduate in a Bachelor of Science in Athletic Training at UNLV, and then continuing on to start a small business, and then went back after we started our law school here to go through our law school here at UNLV. Graduated, have done a clerkship over in federal court with Judge Mahan, did a clerkship with Judge Glass down in the state district court, then went out into practice, worked for now District Attorney Steve Wolfson. That's how I kind of got my teeth cut on doing trials. I'm a litigator. I've practiced in every court and law in the state of Southern Nevada. So I have experience. I do jury trials, preliminary hearings, bench trials. I do appellate briefing all the way up, so I have been around the court system. Thank you.
I'm Judge Jansen, currently in Department 5. I went to school at Michigan State University where I received a bachelor's degree in criminology. I received my Juris Doctor degree in law from Drake University. I was an FBI agent for lacking 2 months, 24 years. I was 18 years here in Las Vegas. I'm currently married to my wife, Nora. And a side note, Nora was a widow. Her husband was killed in Vietnam. And I lost my first wife when after I arrived here. She died of cancer a year after I arrived here. So we were alone for 2 years. So mutual friends introduced us. We got married, and I adopted her 2 little boys, raised them, educated them, and told them to get the hell out of Dodge.
Thank you for your introduction. So we're just going to go ahead right into the panel. We're going to start off with Melody. Yeah.
Judge Jansen,
Yeah.
Veterans Court. How many people have you referred to the Veterans Court calendar, and do you ask as a matter of procedure at the beginning of your docket whether or not a person is a veteran?
Yeah. I try to, yes. And if I know that they're a veteran, I'd send them on to Veterans Court, which is Judge Tobiasen that handles that. I wish they would, when they come in, if they were, well, it's hard because if they let the marshal know that they're a veteran, so we know ahead of time.
Right.
That's the problem. I try to ask, but a lot of times when I ask, when I go into court and I open up and I said, any veterans here? Well, some come in later on, after we've already been in session, so I did not know that. So you can tell your people if they would.
Are you opposed to posting a sign on your door? Or?
Well, we can do that, yes. I don't see any harm in doing that. We can, if that's what it takes, I'll be glad to do it.
Okay.
Sure.
And for the other 2 candidates, I'd like to know what your familiarity is with the Veterans Court calendar and what your opinions are of it.
I'll start.
Use your mic. Use your mic.
I'm familiar with Judge Tobiasen's Veterans Court that is down in Justice Court, and that particular court is a kind of a fix-it because we have the statute in place that authorizes district court to do a full diversionary court for veterans. But unfortunately, there hasn't been the funding for doing that. So Judge Tobiasen created the Veterans Court in Justice Court to act as even though it's not a full diversionary court, but to allow us as criminal defense attorneys and judges to try to provide some additional services and structure, if we have to, on a resolution for a case, something that is better suited and takes into considerations a lot of things that veterans do face in our world today, unfortunately. That's what Judge Tobiasen has done. I know Judge Delaney up in district court, she handles the mental health court and she handles the drug court, and so she's been working on trying to incorporate it as best as she can, but it really needs to be a full diversionary program, and it hasn't quite gotten there yet.
Okay, are you aware, I'm going to go into two things. Are you aware of, one, $7 for every traffic ticket goes to the specialty courts, and the drug court, the Judge Tobiasen could request a grant?
Judge Tobiasen could request a grant from the Supreme Court to adopt the specialty court like they have in Washoe County. Also, the Veterans Administration offsets a lot of the cost for counseling, drug testing, things of that nature that would normally fall on the county and the taxpayers. The actual Veterans Association does take care of that.
Right, and that's what Judge Tobiasen is doing. Is Judge Tobiasen is working on trying to gather some more of the resources that are in their community to provide additional resources to our vets. What's happening is unfortunately what we're talking about is the statute provides for an actual true diversionary court up in district court. And right now, unfortunately, the $7 is being utilized to fund mental health court because they're losing so many beds, and drug court. And I don't think it's fair that the veterans kind of get the short shaft here, and I think Judge Delaney is trying to address it, but I think it's going to take a little bit more action on everybody's behalf to try to implement that full diversionary court up at the district court level. Right now, what we have is in justice court.
Mr. Kurth.
You know, I was actually talking to Judge Delaney yesterday, and I asked her about this because I was at a seminar and they handed out a list of specialty courts, and I saw her Veterans Court on it, and I didn't see Judge Tobiasen's on there. And I was speaking with her about what we thought, you know, how could we improve that, improve the system, and one thing that came up was letting people know about it, because I'll tell you what, I don't think all the defense attorneys are aware of it, and I don't know that the prosecution has done, because how it really works is, you know, you're negotiating a case as a defense attorney, and you want to get that as part of the, you know, as part of your agreement, so that if it's, you know, a crime not involving the use of force or violence upon the person of another, and you can work something out so that they can get the treatment because they are a veteran, and you can push them into that system. But enough aren't being pushed into that system. We're not identifying in the beginning good enough. We could be handing something out, and we're not getting that information out to the defense attorneys and the prosecution office, which I think will work better nowadays with it.
Thank you.
Good afternoon. Thank you so much for being here today. I appreciate it very much. This is the same question for all three of you, and I know no one has a crystal ball in front of them, so I'm asking you to make a prediction here. But the current state of affairs involving our coroner's inquest process with the police department and the community is a very serious issue. What do you see as things that can be done to either improve the current process, get it going again, or to totally end the coroner's inquest process? How's it going? We can start out. Judge Jansen, please.
Well, first of all, I'm precluded from the judicial canon of ethics to answer those questions because we're discussing policy, in which we're not allowed to do so. Secondly, I have recused myself from to hearing the coroner's inquest when we were hearing them, because I personally was involved in 2 fatal shootings when I was with the FBI, and I didn't want to see any impartiality or what have you, me overseeing the hearing, and they come out and they say, well, you know, he didn't allow that question to be asked or that question to be asked because he was partial to the police and what have you. So I'm not involved in that. I will not be involved in it. And as the coroner knows that I had a discussion with him, and that's the reason why, because I was involved in 2 fatal shootings. Okay?
And we all have a little bit of a limitation on this, but what I can tell you is it's going to be a rocky road up in front of us, because it's moving very, very adversarial. Even though they've worked on trying to get the ombudsman to try to make it where it's not as adversarial, it's still shifting very adversarial, so it's going to be a little bit rocky of a road before the public's going to feel comfortable and trusting of our police officers again, and that our police officers are not going to be called to question all the time for there are split-second judgments. Now, I'm not saying that an officer can't make a poor decision in that split second, but I think we've got a rocky road ahead of us before I think this is going to mesh out a little bit better. And it's sad to say that, but that's where we're going to be at for a little while.
The issues in the coroner's inquest process that I see are, we need to protect the community, the members of our community, and we also need to protect the police. And they need to be able to do their job. So we need to find that balance there, which, you know, there's been some issues with that, you know, most recently. And that's why there's so much antagonism, I believe, against it, because now it's even putting the officers now in this position of having to defend themselves, and maybe could they face some possible criminal, you know, penalties. So, you know, we don't want that, because you want everybody to be forthright. We want the truth to come out. So we just need to keep working on that and get it to the right place. And hopefully we'll be there soon.
Thank you for being here. My first. Hello. My first question is for Mr. Kurth. I'm reading here in your flyer here. It says Robert will be a judge who will be tough on crime. That's the first thing you list here. As a criminal defense practitioner, that gives me a bit of pause. I feel often as though the presumption of innocence is more theory than reality in the judicial system. And I'm wondering if you could explain what you mean by being tough on crime and how you square that with respecting the rights of someone who is simply accused of a crime and is not guilty of a crime until proven guilty. You understand my question?
You know, I agree with that. I did clerk for the district attorney's office for a short time before I was licensed to practice law here about 20 years ago. But, you know, and I've been through the system, and I've represented people from all different races, backgrounds, ethnicities, and I've seen overcharging of them. And I've also seen and talked to police officers who I know have worked hard on investigations, and some judge just lets them out arbitrarily. Somebody that's going to come out and pose a danger to the community. Of all these people I've met, and being an arbitrator for the last 10 years, I think have a pretty good judge of character also, which would help me to, you know, look at the defendants that are in the courtroom. I think the sentences need to be tough, but they need to be fair, and they need to be structured to the particular person that is being charged and is being convicted of the crime. Of course, I believe in the presumption of innocence all the way.
Question, I guess, feel free to weigh in on this as well. This is a simple yes or no question for all of you. Substance abuse obviously plays a huge role in the criminal justice system. It's pretty well documented that drugs and alcohol, you know, create physiological addiction. It's a disease, just like any other kind of disease. Ironically, in southern Nevada here, where gaming revenue is, you know, obviously the largest source to the coffers, there still seems to be some hesitance on the parts of some judges to recognize that gambling addiction can be just as crippling and just as real as addiction to drugs or alcohol. So I'm wondering, just a yes or no question, if each of you believes that gambling can in fact be the source of addiction just as drugs or alcohol can.
Robert Kurth, I do believe that gambling is a major addiction. I just handled a case in family court with Judge Elliott where there was some accusations of that, and she threw him right into that. But, you know, because she feels so strongly about that.
Absolutely, and the gaming board already has a gambling addiction facility and trying to help these people.
Yes, gambling is an addiction. I noticed that some of the crimes that have been committed, you asked the reason why, especially in embezzlement, theft, taking out the cash register at 7-Eleven. Where do they go? They go down to the casino and blow it. Now, I could just recently, why the priest who was just convicted and sentenced, there's a good example right there that he had a gambling habit and it was an addiction. So they argued there whether he should go to prison or seek help. Well, the judge sent him to prison. So hopefully when he gets out that he seeks help so he won't have to do it again. Absolutely. Gambling is an addiction just like drugs.
Thank you.
Thank
Go on. I don't know if that one's on.
Yeah, can you hear me?
Yeah.
Okay. I asked this question because before the Supreme Court currently, this question of whether an American citizen has a right to adjudicate a dispute with a governmental authority like the VA or the EPA or any other entity that's a state, or are they required to go through their administrative process before bringing the issue to a judge to seek relief under that issue?
Well, the laws really preclude them from going now straight to a judge. They have to go through the administrative. Like, for example, we really, in our position, we don't get involved in that as much as the district court. You're talking about unemployment benefits. You're talking about people got hurt at work, that they turn them down, or they won't say they weren't hurt at work, or their disability wasn't caused by a work-related incident. They don't come before us. They go to the district court. So we really don't have anything are involved in that. So I would say definitely they're going to have to change the law to do that. But right now they have to go through the administrative procedures and then file a petition in the district court to have their case heard.
Well, I've dealt with people that are having to go through, unfortunately, Social Security disability benefits, and when there's an award, and then they go back and challenge it, and the administration takes away their benefits. Same thing with Postal Service and stuff like that. And it's really sad that they have to go through the administrative process before they can get in front of a court, because that's oftentimes exceptionally lengthy, and people aren't getting the care or the treatment that they need. And so I think that system may need to be reworked, because the administrative law judges are so backed up that people are waiting years before they can even get in front of an ALJ, and then they have to wait for the ALJ before they can appeal that up for additional review. And so I think what is starting to happen is they're starting to try to be a shift to try to clear up some of that backlogs in certain circumstances that you might be able to go up into the district court, but either federal or state.
I mean, Robert Kurth, generally, as what's been stated, I mean, there's a lot of administrative laws in the Administrative Procedure Act, and usually you have to go through and exhaust those remedies before you can go forward. Should they streamline that, maybe give you let you do less of the remedies and then be able to go straight to the district court? Yes, especially in under certain circumstances when people really need that relief right now.
Good afternoon. Thanks for being here, Travis, American attorney in town. This is a trick question. Are you aware of any statutory provision for a defendant who was prosecuted without probable cause to recover attorney fees and costs? Yes or no?
I'm not aware of any. I mean, in court, if you lose, why the losing party has to pay for the other side attorney fees.
I'm in a criminal defendant.
Or a criminal defendant?
Yep.
I'm not aware of it. Right offhand, anyway.
I think there might be a provision under the Civil Rights Act, because I think that would be an issue of whether there was not probable cause, you had to expend attorney's fees to solve the problem, and I think you would have to bring it underneath a civil rights action and bring the claim over in federal court, and then you could seek your damages, which your damages would be your cost and fees that you had to associate with your defense over in state court.
Can I just maybe I misinterpret your question. Are you saying that if there's no probable cause and the rest of their statute automatically that they can be paid their attorney fees?
Right.
That I don't know, but I agree with her. There's remedies where you can file suit of on and off for arrest, civil rights suit, and then go to district court.
Mr. Kurth?
Robert Kurth, I'm not aware of any statute that allows criminal defendants to be afforded attorney's fees except for something under the Federal Civil Rights Act.
Well, I told you it's a trick question. If you have a pen, will you write down NRS 176.115? And it precisely provides for a defendant who's prosecuted without probable cause to recover from the complaining agency, the city, the county, and it's not an action against the prosecutor as the civil rights one. So, thank you.
Have you had any cases of that?
I have the only case going on right now. We're in front of the Supreme Court right now.
I was wondering, because I never had that issue come up.
Everybody said you can't do it. I asked all my attorney friends.
Never
They
say
said,
can't.
thank you,
Never say
thank you,
can't.
thank you,
I
thank
learned
you,
that
Judge.
many years ago when I was
That's
at the FBI.
right. It's
Never say
in there,
can't.
NRS 176.115 as a hedge against overly aggressive prosecution. Thank you.
Hi, good afternoon. Oh. Good afternoon, everyone. My name is Teresa Price. I don't know, can you hear me?
Yeah, you just gotta yell.
Gotta yell. Okay.
Use your Air Force voice.
Yeah. So thanks for being here. I just have a really simple question, sort of briefly as you guys can. Can you tell me if you agree or disagree with suspended sentences for first-time offenders?
Well, I'll answer that. I agree that there should be a suspended sentence. It depends. Here's what it is. It depends on the crime. Now, a lot of times the statute, as you well know, mandates that there's penitentiary time once you're convicted. But where you have a right to have probation, you get probation, suspended sentence, put on probation, pay restitution, counseling, behave yourself, and so then you'll be discharged. If not, then you will go back and serve your sentence. You're going to have that because the prison's overcrowded, the jail's overcrowded, and it puts the burden on their shoulder. You got a break. You got a suspended sentence. Do what you're supposed to, behave yourself, and you won't go to prison. If you don't behave yourself, don't do what you're supposed to, then you're on your way to prison.
This answer is twofold, and I'm gonna take out the mandatory sentence structures that we do have in certain cases, and the mandatory suspended sentence that must be imposed underneath a DUI or a battery DV conviction. But if we're talking a first-time offender, where they are in justice court, which is where I'm looking to be, and they have an early offer that deals with a reduction to a misdemeanor, I do not think there should be a suspended sentence. The reason being is every time you have a suspended sentence and you have someone standing in front of you that first day that they get the early offer and they can't afford an attorney, we just got to appoint them an attorney. So it's a waste of resources. Instead, what could be utilized is a better implementation of the contempt time, because usually the suspended sentence that we're talking about in these narrow lines of cases is 30 days. So if you're going to do 30 days, you can play with contempt time and it's going to satisfy that. But if we're talking a felony or one that does impose a mandatory suspended sentence, then unfortunately you do need to impose that.
Robert Kurth. I think for a non-violent offense, first-time offense, that there should still be some type of suspended sentence in some of the situations. I mean, some of them, we do, something's reduced to like possession of drugs not to be introduced in interstate commerce, do some drug counseling, or pay your fine and it's done or dismissed. There's different cases, but what's been said already is that a suspended sentence does serve a purpose. It serves a purpose of making sure the person completes the requirements. Okay, but I think when they come back before you, you need to be reasonable and see what's happened with them. You don't need to just throw them in jail because they didn't pay all of their fine. And that's not usually how it does work. It depends on the judge and it depends on the courtroom, but it does serve a purpose. I think if you were going to issue contempt or something for someone, that I'd be hesitant in doing that without them having an attorney also, because they could be serving jail time for that.
And due to the fact that we actually had three on the interview panel today, this is going to be the last question. We won't be able to get through all of us. So this will be the last question. Each one will have a minute to answer. So it's all you, Jim.
Thank you very much to all three of you for coming in this afternoon. My name's Jim Jonas. I'm a radio host. The first question I have is for Mrs. Cruz and Mr. Kurth. What is Judge Jansen doing wrong?
Judge Jansen has been an excellent judge for many years, but what Judge Jansen is not doing is moving up to speed in today's world. And unfortunately, Judge Jansen does not embrace where we've gone. We need to utilize technology, and technology is important for you to streamline and get decisions as they're coming down from our higher authorities. Recently, the United States Supreme Court just issued a very critical decision that deals with constitutional rights, and as recently, the Nevada Supreme Court has also issued a published decision that deals with the evidentiary admission in DUI cases. So if you're not electronically connected, you're not going to get these opinions until weeks, maybe months later, and you can make a bad decision, and that can affect somebody's life. So one of the things that I think is important is, if I get elected, is to embrace technology and bring it into this courtroom and get it up to speed, because I am very versed in electronic research.
You know, I think it's time that it wasn't a lifetime appointment, it wasn't a lifetime election, and that it's just time that we have some new people in there, such as myself, and that I'll be there and I'll finish my term. I'll do the 6 years and I'll work hard and get it done. And I'm not so sure that you know, nobody knows what's going to happen to anyone during that period of time, but I think we need to look toward that.
Judge, the question I have for you is, what do you want to accomplish with another term?
To keep going, doing what I have done for the last 26, going 27 years. I know that a lot of the attorneys, they want me back on the bench. I run a smooth courtroom, and I love the work. So I want to respond to her question about the electronics. We get the cases, we have a law clerk that soon the cases are in from the Supreme Court, they're handed down to the judges. We have them almost the same day or the next day of major decisions in the Supreme Court that will affect our caseload, especially the criminal field, which I'm involved in. So, but I'm not a computer. I'm not going to sit there in my office and play in a computer every day. No, I'll tell you that. But I do have access to the cases either the day they're handed down or shortly thereafter.
Thank you, Judge.
Yeah, and with that, this will be the,
Actually, I have something I'd like to say.
you got about 30 seconds there, Karen.
Well, I'll take the time.
You're in trouble now. Karen's coming after you.
My name is Karen Steelman. I'm the Civilian Auxiliary Director for Veterans Employees. And I just wanted to more or less just make a statement that it's human nature that we all kind of forget that our elected officials are elected by the people to serve the people. And it's human nature to get really comfortable in that position and forget what you're there for. So I would like to know what each of you wants from being a judge, and how do you think you're going to obtain that? And how do you think you can obtain that better than the person sitting next to you? Start with Mr. Kurth.
You know, Robert Kurth. As I said, I'm in my 20th year. I've raised my family here, been involved in business here, and been involved in soccer and scouting and a little bit of everything. And I'd like to give back to the community. I'd like to put somebody on the bench like myself that's going to be fair, that's not going to legislate from the bench, somebody that's going to enforce the Constitution, somebody that's going to protect our rights and protect our families, and somebody that's going to be energetic, work hard, work diligent, and knows what the people of our community have gone through, who has represented them in courts throughout the state of Nevada, and can understand that best to help to meet their needs also. And that's what I'll bring to the bench.
I don't think there's going to be any question that all three of us, if in that position, we're all going to be fair judges. I think we all have an understanding of the dynamics that happen in court every day. What I want to bring as an elected official is I want to bring diversity into the courtroom. I want to bring somebody who has an understanding and seeing sides from all three sides. I'm a defense attorney. My family's been in law enforcement. I've represented victims, and I've been a victim myself. So I think I bring a very unique blend to the court. Like I said, I want to get the court up to speed in technology so that it's streamlined even better. But the other thing is that I want to always remember for the 6 years that I am elected by the people in this community. So that is my goal, to stay out in the community, to stay with a contact. Now, I'm a judge and I can't discuss a lot of cases, but I don't think that precludes me from being out in the community to being sensitive to what's going on.
Being a former FBI agent, I brought street sense to the bench. And I've dealt with a lot of individuals when I was an agent and understand people. And that's what I brought to the bench, so I can understand the individual and work with him. I know the RJ and the Sun said I'm a fair and firm judge. When I lectured at the police academy, I told them, in search and seizure probable cause, I said, if you do opposite what I told you, I'll be the first one to rule against you. First week I was on the bench, I threw out a drug case. I threw out 2 murder cases because of the fact that they did not comply with the rules of evidence. So I try to go along with the rules of evidence, be fair and firm, and I think if you talk to any of the defense attorneys in town, they will tell you that I run a good courtroom and I'm firm and fair.
And with that, thank you for running us off track there, Aaron. And so Judge Jansen, Ms. Cruz, and Mr. Kurth, thank you so much for making yourself available to Veterans in Politics and opening yourself up to our panel. Thank you for your time.
Thank you.
Our next interview will be from the Vista Township, Las Vegas Department number 8 with Amy Cellini and Judge Zimmerman.